morning, Mr. Harwood.
Good morning, Your Honors. I'm Attorney Don Harwood on behalf of the defendant, Manuel Santos. I'm going to be discussing, for the most part this morning, the Brady issue, and my brother counsel, Mr. Barter, who represents Mr. Caillot, will be discussing mostly the Crawford issue. The Brady issue in this case is significant. I cannot find a case in the research where the Commonwealth has suppressed the two murder weapons.
Why isn't, at least as to one of the weapons, why isn't your argument foreclosed by our discussion in Caillot 1?
It's not foreclosed because in the decision written by Judge Ireland, he made very clear that the Brady issue could be brought up at a second time. He considered certain evidence as concerns gun number 3 under a different standard, the Gray standard, with respect to the new trial motion, because when Judge Sikora previously granted a new trial, he only considered evidence as to 3, gun number 3. The Commonwealth discusses the evidence as to both gun number 2 and gun number 3. Indeed, there is other undisclosed evidence as to gun number 3, which was never considered, nor were findings made by Judge Sikora. But the standard under Brady is very different. Under Brady, as we just saw in the last case, in Gallarelli...
But excuse me, he discusses it, it seems, doesn't he discuss it under the Tucheri-Daniels standards?
No, he discussed it under the Gray standards, doesn't he?
No, under Grace. And Judge Ireland made very clear, he said, you can bring up the Brady issues if and when you deem it appropriate. He said that in a footnote very clearly. And that's what we're bringing up now. We're bringing up the Brady issue. And under Gallarelli, the issue and the standard of review is different even than the federal standard. In Gallarelli, this court affirmed Article 12 is more protective. The Agers standard remains. If there's a specific request for evidence which is undisclosed, then this court has to be basically sure the standard is that it did not influence the jury or had but slight effect. And Tucheri says that as long as a defendant can show a substantial basis for claiming prejudice, then a new trial should be granted. Now, in the course of what I'm going to discuss this morning, I will at points refer back to Caillot 1. But the Brady standard is much different. And we say under either the state standard, which is extremely protective, and even under the federal standard, which is also protective, especially where you have material evidence like the two murder weapons, relief is
you have
mandated.
Evidence like the two murder weapons. You also have evidence that those same weapons were used in subsequent crimes by different people.
And that's the critical thing here. And I think...
Was none of that brought out at the trial?
What wasn't brought out was gun number 2 was recovered on March 4... well, rather it was recovered in June 3rd, 1998. This is 4 or 5 months before the trial. And Joseph Watkins was in possession of the weapon. And this court has held in numerous cases that a suspect in possession of a murder weapon, that evidence can be used to prosecute someone. So in this case, Watkins was arrested and charged with possession of the weapon. It was not disclosed that Watkins was the person in possession of the weapon.
No, but I'm asking you, was it disclosed at trial that the weapon was used after the defendant's arrest?
What was disclosed was that with respect to this weapon, on March 4, 1998, there was a shooting of a Jerry Dessalines. What was the only thing disclosed
so
that...
it was disclosed that this weapon was used after the arrest?
Yes.
That was in evidence at trial?
Yes, with respect to the shooting of Jerry Dessalines. And what the Commonwealth provided was a one-page ballistics report which said one casing was found at the shooting of Dessalines. What we found out as a result of discovery, court-ordered by Judge Sikora after the fact, was that, in fact, there were 8 casings with respect to the Dessalines shooting, that a white car was what fired the bullets into the Dessalines car. And in the Santos case, a neutral witness, Harold Beston, testified that Murphy was shooting at a white car as it fled the scene, not a green Cirrus. So the reports after the fact, instead of a one-page ballistics report, you now have a diagram of the Honda that Desling was traveling in that wasn't disclosed. You have a white car being the car that fired into Desling. You have 8 shells instead of 1 shell. In Rodriguez, the Second Circuit case, they make crystal clear, it's not enough to give just one part of Brady. If there are numerous parts of exculpatory evidence which could have been used, a blanket, in that case it was a witness saying, yeah, the witness lied, and the remand was necessary to determine in what particulars did that witness lie. Here you have 1 shell casing instead of all of this evidence, including a white car, that could have been used by the defense but was not, because this evidence was never turned over to either of the defense counsel prior to trial. With respect to gun number 3, what was not turned over was that Donald Averitt, was found in possession of the weapon on April 10, 1998. And remember, in McLaughlin, this court said finding somebody in possession of a weapon 10 or 11 months after the fact still is enough to prosecute him for murder. Here we have Averitt in possession, arrested, and charged with gun number 3. And this is what's so critical. He is charged with shooting to death somebody, Alexander Caillot, at the same intersection where this incident occurred, in Brockton.
And he
at
was
Nielsen.
acquitted, and he was acquitted of that.
He was acquitted of that, but Brady doesn't turn
No, I understand
upon
it.
whether somebody is acquitted. Brady turns upon...
Excuse me, I'm aware of that. What was the evidence at trial regarding gun number 3?
Well, at which one? At our trial? Nothing.
Yes, at your trial.
That wasn't disclosed at all. So you have a suspect who is arrested with gun number 3, shooting to death somebody with a co-defendant, Lawan Melton, at the same intersection, at Bud's Variety. Where were the cartridges found in this case? Bud's Variety. Where did they shoot to death Cologne? From Bud's Variety. And Melton admits this. He says that he had one gun and Averitt had the other, and he does say that he was the one shooting the Glock. There's another witness, Jennifer Perez, none of this being disclosed, that actually saw these 2 men shoot into the Cologne car. Of course, the defense knew nothing about that. So none of that evidence was disclosed. Substantial links is what the Commonwealth says. There's no evidence of substantial links. Substantial links, these are the murder weapons. You won't find another case where murder weapons are suppressed, and it even gets up this high to appeal. The closest thing you'll find is this court's reversal and dismissal, affirming it in Lam Hu To, where 2 knives are found near a scene that were possibly the murder weapons. There it was reversed, and the only question was, do we dismiss it with prejudice or do we let it go on? In addition, they didn't disclose that there were 5 prior incidents involving gun number 3. And the Commonwealth says in its brief, oh no, these 5 prior shooting incidents in Brockton involving gun number 3 were disclosed at the trial. Well, in fact, the Commonwealth refers to a report in the record. These 5 incidents were disclosed after the trial by Ms. McKenna in November of 2003, once Judge Sikora ordered it. So Mondano stumbled into it and said, we do have evidence of other shootings at the trial, when Arnold says, oh yeah, there are a couple of other shootings. It's not that Mondano had reports prior to the trial, like the Commonwealth is trying to say in front of you this morning. The reports weren't disclosed until November of 2003, and Mondano says to Arnold, we do have 2 other shootings? And he says, oh yeah, we have 2 other Brockton shootings. This is in her brief, and they're in Brockton on these dates. And then when I saw this in the brief, I asked myself, well, if Arnold had made a connection on 2 other prior incidents, and this state police lab is so rudimentary that they can't make connections, if he made the 2 connections at the time of trial on those 2, why hadn't they made connections on these other ones that had just happened 5 or 6 months ago? You know that Trooper Wakefield was asked by Arnold, shouldn't we do more testing? We do have a hit here on a gun. And Wakefield also investigating the Cologne murder where they shot at the same intersection and killed. And she says, no, we don't want to do that. And you can look in the record at her declining that request with ADA Sullivan. But we don't know when that conversation occurred.
Mr. Harwood, let me ask
vis-a-vis Wakefield.
Let me ask you this, because you heard the questions earlier. This is coming up not infrequently. What do we do? I mean, it's one thing to look to see whether, in fact, given the circumstances and so on and so forth, whether relief should be ordered. But what do we do about the failure of state police to hand over information to the prosecutor when, in fact, we say you have to go through the prosecutor?
You have to set a precedent. You have to say that you can't disclose 2 murder weapons, fail to disclose 2 murder weapons, and walk away from it. One thing is clear under the case law. Whether the prosecutor knew or not isn't relevant for Brady purposes.
No, I understand that. My question was going to my question was going to a somewhat different point. It's very to order a new trial, let alone to dismiss the case, which is what you've asked for. Is very powerful medicine. There are witnesses, time delays. When was this homicide?
This was November of 1997.
Okay, so we're 12 years later.
It's even harder for the defendant.
No, I understand
8
that.
years
But what
after
I'm
the
saying is
fact.
I'm trying to think of procedures that we can put in place so this doesn't keep happening again and again and again and again.
The one procedure is to make crystal clear, perhaps under Article 12, but it's already been made clear that the good faith of the prosecutor is not the relevant thing. If the police don't turn it over, whether it be Trooper Wakefield or whoever it is, there has to be a consequence. And I would touch upon, for Brady purposes, admissibility is not the key, and this was mentioned in Caillot 1. Every circuit except the Fourth Circuit who's
No, I
considered
understand
this
that.
has
I understand
said
that.
it's whether it leads to evidence. So the First
Correct.
Circuit in
No,
Ellsworth.
I understand.
Okay. So this evidence, had it been disclosed, would have led to direct evidence, like Jennifer Perez saying, I saw them shoot these 2
No, I
people with a
understand.
block gun.
I understand.
And in terms of prejudice, this isn't just issues of fingerprints and DNA. These are the murder weapons. You can't suppress the instrumentalities of a crime, especially when you have alternative suspects. Caillot and Santos were never found in possession of these weapons. 2 alternate suspects.
Didn't they argue that in trial? Didn't they
Yes.
argue it? And that was their defense at trial, was that other people, these guns weren't discovered and other
Right.
people had access to them.
And what did the prosecutor say? The prosecutor represented to the jury, he represented to the jury, we never recovered the weapons when they were testing them at the state police lab 5 or 6 months
But
ago.
didn't at least that much accrue to the defendant's benefit, the fact that they hadn't been recovered and they couldn't be tied to these defendants?
If you're the jury sitting there and you find out that another black man matching the general description possessed the murder weapon and shot somebody at the same intersection, how is that not Brady issue? How is that not
If the
something
Commonwealth
that...
then brings in evidence that these then would bring in, presumably, so-called expert police testimony about community guns.
That's what they say,
And the jury
Judge.
would get to hear all the terrible evidence of community guns and how bad people share these and kill all sorts of people and just leave the gun in a hiding place. Is that going to accrue to your defendant's benefit?
That's a theory that they're presenting, and that's not for me and not for this court. It was for a jury to decide. The jury is the fact finder. If they ignore the evidence that it was a white car and there were 8 shots at Desaline, oh, so be it. Let the jury decide. If they decide that Everett shooting the Glock and killing somebody at the same intersection where Claremy was killed, that that's a community gun, so be it. That's after-the-fact speculation. It's not based on the evidence, and it's certainly something that a jury should decide. You can't suppress the murder weapons and the alternative suspects who are linked to them, which this Commonwealth's precedent makes crystal clear can be used in a prosecution of Everett or Watkins by the possession of it, you can't suppress that and then later say, no harm, no foul.
Thank you.
I would rest on my brief as to the Crawford issue, and as to the ineffective assistance of counsel issue. I think I briefed that as well as to Howard in showing the implausibility of Murphy's testimony, the fact that the ballistics evidence indicated it was a shot into the side, just like Santos said. He said that he saw a burn mark on the side of the car. The two side windows are blown out, but not the rear window, which Murphy somehow says he shot at a fleeing car. And I would rest on my brief for the rest. Thank you.
Thank you, Mr. Howard. Mr. Barton? Please go ahead, Mr. Barton.
Good morning, Your Honor. Thank you. I'd like to address a couple of the comments with regard to the Brady issues before spending at least a few minutes on the Crawford issue. Justice Cowan made a very good point that didn't this inure to the benefit of the defendants at trial? They were free to argue, the guns were never recovered. Obviously, if the guns were recovered in the hands of somebody who met the description, if they were subsequently used, that's more powerful. And what we have is a Sixth Amendment right to effective assistance of counsel, a due process right to have evidence and to have a fair trial. And it's the defense that should be deciding which argument is most powerful. The defendant, in conjunction with the defendant's attorney, should be deciding, is it more powerful for me to argue that this gun was recovered by someone who met the description of the assailant, or is it more powerful for me to say the guns have never been recovered? I'd suggest the first option would always be the one that's chosen, but that's not my judgment here as appellate counsel. What I'm saying as appellate counsel is this is a right to counsel issue. This is a Fifth Amendment issue that should be decided at that level. And that's what Eggers was all about. Eggers, as the court knows, was decided back in the 1970s, and Ellison was one of the first major cases in this court that discussed the exculpatory evidence issues. And Justice Kaplan, in the decision in Ellison, pointed out that it shouldn't be the defendant who has to carry the burden of the Commonwealth failing to disclose evidence.
Well, it isn't the defendant.
Exactly. On a couple of other points, Your Honor, Chief Justice Marshall asked, what are we to do? I think that what we are to do is to strictly apply the footnote in Gallarelli that said Eggers is still good law. Strictly apply Justice Kaplan's analysis to the effect that the weight should not be put on the defendants to show that, as Commonwealth versus Grace would have in a typical motion for new trial standard based on newly discovered evidence, the weight should not be put on the defendants to show that they would have gotten acquittal otherwise. The presumption should be in favor of granting a new trial in each and every one of these situations. If we want to draw the presumption more narrowly, well, the presumption should be any time that evidence of another suspect isn't disclosed, any time that evidence concerning the actual murder weapons isn't disclosed, there should be a presumption of a new trial. In fact, every time that evidence directly bearing upon instrumentalities of the crime has been considered by this court in earlier decisions, in Gallarelli, Lamhuto, and another case that's cited in our brief. In each of those situations, the new trial was granted. There wasn't a discussion of a presumptive rule, but it was almost an inference that, of course, the instrumentalities of the crime are material, and being deprived of access to those does cause damage. If this court has any questions, I know Mr. Harwood ran low on time. I'd be glad to address any questions that the court may have on the Brady issue as well. But I would like to have the opportunity to address the other significant issue that I'd like to touch upon here, and that's the Crawford issue. Crawford was decided after this case was tried, after the motion for new...
If we assume Crawford applies,
Yes.
as you argue, and I think correctly, does Crawford apply to hearsay statements, given footnote 9 in Crawford?
Yes, Your Honor.
The last sentence there says it doesn't, at least to my reading.
Well,
It says in footnote 9,
footnote 9 is...
in the last, in parentheses, the confrontation clause, also does not bar the use of testimonial statements for purposes other than establishing the truth of the matter asserted. And they cite another case.
Yes, Your Honor. Footnote 9 has been described as the fodder for future law review articles. I spoke to the attorney who represented Mr. Crawford in the Supreme Court, and he's already written a short article on the subject. He expects that footnote 9 will continue to be reviewed by the courts for some years to come. And I don't know that he has all the answers to this, but the point is, this is a footnote, which is dicta, and the portion that Your Honor points to is a parenthetical within the footnote dicta, and it cites a very particular case, the Street versus Tennessee case. And in the Street versus Tennessee case, what happened was the evidence was admitted really for purposes of cross-examination. The jury was so advised that the evidence was not being admitted for purposes of the truth of the matter. And Your Honor, I know, is very familiar with this, having decided Commonwealth versus Diaz so recently, Justice Cowan having written that decision. That very issue was raised in the Diaz case, as you'll recall. That's just back in February 24th. In that case, the Commonwealth made a similar argument that it was not admitted, it wasn't admitted for the truth of the matter. And as this court pointed out in that case, nevertheless, Crawford did apply, and the analysis that Your Honor got to was this material? Was this evidence damaging to the defendant? And Your Honor also mentioned there was no limiting instruction. So this gets to the Tennessee versus Street analysis mentioned in that footnote in Crawford. The cases in this jurisdiction, including the Peltier case, which was decided by the appeals court just last year, and I believe it was the Taylor case, another case of this court, have touched upon that footnote 9 issue. And in each instance, the question has been, was this evidence used for substantive purposes, and was there a limiting instruction telling the jury so? In our case, there was no such limiting instruction. In fact, this evidence that we're talking about here is the statements upon which the entire motive theory of the case was based. And the entire motive theory of the case was based upon the notion that Mr. Santos, not Mr. Caillot, but Mr. Santos, told a police officer that the assailant shooting into his car when he was being carjacked was the same person who shot Herbie's cousin 3 months earlier. Keep in mind, he didn't say the man that Herbie and I shot was the same person. He never said that they were involved in a shooting. He simply said someone came by and shot in the window, and it was the same guy who shot Herbie's cousin. Now, the Commonwealth didn't say, well, that's only admissible for purposes of impeachment. That's only admissible for some limited purpose. Instead, the Commonwealth said, there's no reasonable doubt here. There's an intent here. We know why there's an intent. The intent was they wanted to commit a revenge. This was premeditated. He had a motive. He helped him with it. That, ladies and gentlemen, is premeditation. That, ladies and gentlemen, is an intentional murder.
Right, but doesn't that essentially say that it was being offered for the state of mind of Mr. Not Caillot, Mr. Santos? Because if the jury truly believed, if it was taken for the truth of the matter, they would have acquitted him, because the Commonwealth was offering it not because it was true. The Commonwealth claimed it was a fabrication. The Commonwealth was offering it
Well,
simply to show what was going on in his head at the time.
It's so difficult to parse this out, but to say, well, the Commonwealth can base its entire closing argument and its entire motive theory upon a fabrication and not tell the jury, oh, you know, this stuff isn't really true, but why don't we go ahead and say that it proves that it was an intentional murder? So the truth of the matter that the Commonwealth was trying to assert here was that the defendant, Santos, believed that the person who shot in his window had shot Mr. Caillot's cousin 3 months earlier. So it is being submitted for the truth of the matter. Even if the truth were an erroneous state of mind, they're not saying it's admissible. They didn't ask for limiting instruction, for one thing, so the Tennessee versus Street analysis doesn't work here. It wasn't for a purpose such as cross-examination or for purposes of showing some operative words. They were using it as affirmative evidence that these men committed this crime. And so I understand, Justice Gantz, your comment, but I think that once we look at it, we won't find any other cases, and this court so noted in Commonwealth versus Lau. In Lau, this court overturned a case on a motion for new trial status on a Crawford issue because evidence came in with regard to motive. And the same argument could have been made there. Oh, well, you know, motive isn't truth. Motive isn't the truth of the matter. But it's quite certain that motive evidence is submitted and accepted for purposes of proving the case, even though it's not an element of the offense, but it proves each of the other elements when it is available. And I'd suggest that in this case, that the Commonwealth's argument that it wasn't submitted for the truth of the matter stated comes late. They never requested a limiting instruction, as Justice Cowan pointed out in the recent Diaz case in analogous circumstances. And motive is not, by definition, something that the Commonwealth can always put in without any concern for the Sixth Amendment right to confrontation. Thank you.
Thank you, Mr. Barter. Ms. McKenna?
Good morning. If it please the Court, Gail McKenna, Assistant District Attorney for the Commonwealth. This is a case where we have a judge of the Superior Court who wrote a decision and made a finding that the evidence here was newly discovered, newly available evidence, this being the handguns and the additional ballistics evidence that was matched up after trial. The defendants here have not even attempted to make a case that this evidence, that the judge's finding here, which is what the issue is before the court, is clearly erroneous, so that the judge in this case abused his discretion in making these findings. As this court pointed out in its decision in the first Caillot decision, this judge found there was no Brady error. So there is no Brady issue before this court.
Well, help me to understand.
Sure.
When did the state police know that this gun had been matched up with the shells in this shooting?
After trial. We're not sure exactly when after trial, but after trial. What happened was, and the uncontested evidence at the evidentiary hearing was, the evidence from the defendant's witness as well, Mr. Majensky, was that as ballistics evidence is developed and comes in, it's entered into worksheets. The worksheets are running sheets. So essentially they're snapshots. The snapshots, working sheets that were provided right before trial, didn't show any guns, any matches to any guns. None had been made. Although the guns were physically in the custody of the ballistics unit, no one had any idea that there was any connection. Essentially, they're fungible, and until
Excuse me, Ms. McKenna, what do you mean essentially they're fungible?
Well, a gun looks like a gun. And until a cartridge casing, the meticulous job of matching a cartridge casing to a cartridge casing happens, no one knows that there's a match.
Did the police have evidence before trial, not whether they made the link, but did they have evidence before trial that the casings matched the meticulous examination that the casings matched the weapon used in this case?
Absolutely not. There's no evidence of that whatsoever, and the judge found to the contrary. And that's what we're dealing with here, is a finding of a Superior Court judge. He found there was no Brady violation, which is why he, in his decision, is quite clear. He decides this as newly discovered evidence, which is why the judge then goes into the analysis, the Grace analysis, and why we're talking here about substantial connecting links to what is subsequently discovered newly available evidence in the case. But there was no Brady violation here. I mean, an analogy, and I actually hate analogies because they're usually inapt, but one here would be if, say, a fingerprint was found at some other crime scene 2 years later, and the defendant said, well, somewhere in your files is a fingerprint that matches, but there's no automated system that allows you to go through all the fingerprints, so you have to go card by card by card. Well, the state police here in their ballistics lab had no automated system at the time. They had to go cartridge by cartridge, which is a painstaking process of comparing cartridges. And as they continued in 2000, it's undisputed that in 2000 there was a drug fire report that came up with the match. That's 2 years after trial. And that's when Wendy Wakefield was contacted 2 years later. Nothing came of that. Eventually, during the evidentiary hearings, discovery was turned over, and yes, that's at the point when the Commonwealth, as well, the prosecutor's office, as well as the defendants, found out there'd been a post-trial match to the weapons, as well as to 2 additional shootings. At trial, there was evidence that guns had been, before trial and after trial, before and after the murder here, had been in circulation. So it was no secret to the jury that
Was
these...
that as to both weapons, number 2 and number 3?
No, that was as to weapon number
2.
2. Yes, thank you,
So
Your
there was
Honor.
no evidence that number 3 had been used after the murder here?
Right, but there was evidence that it had not been recovered.
Right.
So the defendants were able to capitalize on that and to argue to the jury that the evidence that the weapon hadn't been recovered, and to sort of make this generalized argument that, hey, it could be anybody out there. Instead, now what they have to do, and which they've been unsuccessful in doing despite extensive evidentiary hearings, is to come up with a specific culprit that they can tie to this murder instead of them.
Ms. McKenna, forgive me, when was the trial in this case?
It was in 1998, Your Honor.
When?
September 1998.
At least according to the findings, and I just want to make sure that I understand. In May of 1998,
Right. One of the guns was recovered in May of
and
1998.
tested the same day.
The cartridge was expelled the same day, but no matches were made. And that's why Judge Sikora made the
Well,
finding.
it said the testing matched the gun to casings.
I'm sorry?
The testing matched the gun to casings. I'm just trying to understand what happened here.
Can you refer me where you are?
Paragraph 4 of the newly discovered page in your, it may have been in your earlier brief. No, it's in Mr. Barter's earlier brief at,
Well, Your
Record
Honor, I'm looking
Appendix
at the
9.
judge's decision, if that's at all helpful.
It's, let's see if he doesn't have numbered pages and his paragraphs changed, so, it's,
Well, I think that what's key here is the judge's findings that before the trial, we had custody of the suspected murder weapons, and he said putative knowledge of the suspected continuing use of the weapons and shootings after the murders. He says next, at the same time, no individual or group of individuals
no,
within
I'm
the...
looking at earlier ones. It just says the testing was done in May 1998.
The undisputed evidence was, Your Honor, that the only testing that was done was the shooting of the weapon, and a cartridge was produced. In other words, what the testing was production of a ballistics certificate that said that this is an operable weapon. Because the judge's findings, I don't have a finding that says
Okay.
And I'm looking here at the judge's report. I'm sorry, I'm not quite sure where you are.
Well,
But what he did find is that that no link had been made. I mean, no one was aware of the significance of this gun to this crime. The only way a link could be made was through matching of these cartridges, and no match had been made until after trial. The judge found that. I mean, he even entitles this section of his findings, newly discovered evidence of subsequent use of the probable murder weapons. And the defendants in their brief even call them the alleged murder weapons. So, I mean, even they aren't conceding that these are the murder weapons in their presentation here today before the court. But here we have a finding by a judge that's unassailed by the defendants, and did he commit an abuse of discretion? I would say no, based on the credible evidence in the case. He made findings based on the evidence that was before him. The burden then is on the defendants to come up with a third party, someone else who could have done this crime. And they have an uphill battle here for the additional reason that the Commonwealth had a third person there at the murder scene. We've always said that there were 3 people there. So they have to be very careful not to point to the other person that was at the murder scene. Instead, that they've pointed again to Donald Averitt, and we've already cleared that the first time in the first appeal that wasn't, what they came up with was not sufficient. Now they're pointing to Jerry Desalinas, and why they choose particular people I don't know, because we have all kinds of descriptions of all kinds of people that were in contact with or shot this gun in all kinds of different circumstances. So to say that any one of these, and why any one of these isn't particularly the third-party culprit that might, instead of these particular defendants, because the standard is that it has to be this person and not the defendant that did the crime in order to somehow be admissible, still just hasn't developed beyond pure speculation. And what
as we look back on this today, as it is in front of us, do we apply any different standard than what was applied to the motion for new trial when we reviewed that back in 2007?
No, the judge applied the Grace standard, and Your Honor would also apply the Grace standard.
Do we apply any other standard, substantial likelihood of a miscarriage of justice, for example, as we examine everything that happened or didn't happen at the trial and that was discovered?
Yes, you apply substantial likelihood of a miscarriage of justice, because this is the direct appeal and the appeal from the denial of the motion for new trial
Ms.
together.
McKenna, may I ask you this?
Certainly.
With respect to the Grace standard, many of the cases that discuss newly discovered evidence, it's newly discovered evidence that's not in the hands of the Commonwealth. You know, it's an investigator goes out and there's or they get a new expert that
Sure.
looks at
A new witness no one knew about.
whatever. I mean, you know the whole range of things. Where's the case that what's the closest case that says the Commonwealth had the evidence before trial, didn't make the connection, but there's no question they had the evidence. So we're not looking at intent, or even, but the Commonwealth only discovered it after trial.
Well, I think they're the cases, and I don't have a name of a case, but on newly available evidence. So maybe it would be a case, for example, on DNA might be a good example, where you have evidence, blood evidence.
That's a little different, because that's you may or may, if I mean the equivalent, if you're using a DNA analogy, and as you said, the analogy is always different.
Right.
If the Commonwealth had actually run the test on the DNA evidence beforehand.
Well, what if you have blood evidence from 1981 or 1970?
I'm talking about where, for some reason, the Commonwealth, we're now talking about, the 21st century, they have the evidence, they run the test. Whoever's running the test just doesn't recognize that it's connected. They're looking at it for case A, and they don't realize it's connected to case B. In other words, here the Commonwealth had the evidence before trial. It didn't make the connection. But in any case, the evidence is coming from the Commonwealth. not tests by the defendant, where's the case that said in those circumstances we apply the Gray standard?
Well, I think I don't have a case directly on point, Your Honor. I think it is like the cases having to do with newly available evidence, and I think
Well, it's a little different. It's a little
I think
different.
it's
If maybe I could possibly be of assistance. In
Thank you.
Leguia, the fingerprint was available. It existed, but the Commonwealth didn't. The prosecutor didn't have it. The police had it, and the front page wasn't. The top page wasn't given over. So that's somewhat similar. And in that case, the Tuccieri-Daniels standard was applied.
Right, but that case was a little different because it was more like I think Gallarelli in the case that there was a report that actually existed. Something had actually been done and
So here
wasn't
you're
turned
saying,
over.
although
There was nothing
the
done.
police had the ballistics evidence, the testing hadn't been done.
It would be like looking at this piece of paper but having absolutely no idea that it has any connection to anything else anywhere in the Commonwealth. I mean, that was essentially where the state police were. I mean, we had at least 14 open shootings at that time. There were cartridges coming in from all over the place, and this cartridge wasn't distinguishable in any particular way from any other cartridge. I mean, the guns came in 2 years later. It's not as though they came in with a connected crime, and that's what distinguishes it from Lam Ho 2 as well, where the knives were found right at the scene and not turned over. I mean, there just was no obvious or apparent connection here.
I understand that, but you understand that it's difficult here because here the Commonwealth, as you heard, I forget whether it was Mr. Harwood or Mr. Bart, at least Mr. Harwood makes it in his brief.
I can't hear you.
I'm sorry. I can't remember whether it was Mr. Harwood or Mr. Bart saying the Commonwealth is making a representation. And we're not talking about intentionality or anything like that. To the jury that says, weapon never discovered. And in fact, the weapon had been discovered.
Well, and the defendants are jumping for joy because they like that representation. I mean, let's be quite clear
That's
here.
your view. That's
well,
your
no,
view.
I think that looking objectively at the case, that the defendant's case deteriorates at the point when they have to come up with a third-party culprit here. No matter what they've argued here today, their case deteriorates. Who have they come up with as a third-party culprit in this case? No one. They've come up with a cast of characters from all over Brockton that have all kinds of different things to do with this gun, different victims, different people, of all sorts of different descriptions. I mean, at trial they had a far better defense, which was it could be anybody, and the police just haven't come up with these guns. The analogy here that really is quite a lot better is to a test that doesn't exist yet, like DNA in the 1980s. You have a blood splatter, but nobody knows how to test that for DNA. When we figure out the test later, then it becomes newly available. I think that's a far better analogy. I mean, it wasn't that anybody wasn't doing their job here. The police went through the evidence, and eventually when it came to light, there's a new trial motion, it's turned over. And then we do the job under the standards this court has set, and we look at it. And the defendants have all the information now, and what have they come up with? Pure speculation.
Now, in 2000,
Nothing.
when it was it revealed because they had developed a computer program to do a search of all of the available shells through some kind of a fingerprint type match, or was it done because of more traditional hand-by-hand inspection?
The uncontested testimony from both witnesses, the defendants and our witness, was that this drug fire system was not reliable, that if it came up with a hit, the only way that the hit could be substantiated was by a hand examination of the items. And that hand examination wasn't done because the evidence was still at the Brockton Superior Court. And one of my brother's complaints is that the officer who 2 months later came in and ended up being the evidence officer didn't go and get the items and bring them back, which is part of their conspiracy.
Okay, but help me
theory
understand.
in the
When
case.
so I gather what they had was a computer hit, which meant that
in
it may be,
2000.
but you can't really verify that it was until you look at it by hand. When
Right.
did the computer hit come?
2000.
So that was well after this case.
Right, right, right. And this is, again, distinguishable from something like fingerprints, where fingerprints, there's something of an automated system which kicks something out, and then there's a hand examination. Here, everything has to be done by hand. It's painstaking. The computer system, at least at this time, everything was so rudimentary that it had to be done painstakingly. And at the same time, new work is coming in, and all of this is testified to at the evidentiary hearing. And we have a judge here that made a finding, and no argument by my brothers that those findings are clearly erroneous.
Let me ask you this, because I keep looking at footnote 8 in the 2007 case in which we reversed the granting of the motion for a new trial.
Right.
Could you explain to me what we meant in footnote 8?
I think what you meant was that you were pointing out that the judge found no Brady violation, and that you would take up the other specific things having to do with the other evidence that came in. The Dessalines or the whatever other issues that the defendants had to do with the specific evidence that was disclosed later in the evidentiary hearings. That's what I took it to mean. That's what I represent in my brief that it means. I only have a couple of minutes, and
I'd like you to address, if you would, I've been waiting, the statements.
Yes, I'm anxious to do that.
Probably, but I have specific questions on them. I understand your arguments as to some, but I don't understand your argument as to this, when Caillot is complaining about the statements by Santos made while Caillot was in the hospital and Santos was outside, the statements about the hijacking.
Right.
He said he didn't know who did it, and it was some person who tried to kill. What is your argument there?
Well, my argument is twofold. My argument is first that that Crawford says quite clearly that any statement that is non-accusatory is not under the Confrontation Clause. And my other argument is that statements of co-venturers are by definition non-testimonial.
But this is after the ventures ended.
Well, I would say not, Your Honor. They're both selling to the police here a false story, which is that there was a carjacking. One is saying I was laying down in the car and shots came out of nowhere. I put my hand up, I got shot. The other one is saying we were victims of a carjacking. And as the judge found, it was a strategic measure on the part of defense counsel to.
And there was never a motion to sever here.
No, there was no motion to sever. So we're talking here about whether counsel was ineffective, and I have findings here from a judge, which again are unchallenged. Essentially, that I don't want to overstate that this was a strategic matter. I mean, how on earth do you put in half a statement? The statement here was, I didn't do anything, essentially, or I'm sorry, I'm rushing here a little bit. The statement here, and again, there's no interrogation, I want to make that clear too, and all the statements came in unobjected to, and the statement is, what, do you think I murdered someone? I was carjacked. That's a whole statement. And now, on appeal, the defendant wants only the I was carjacked? I mean, the whole statement comes in. And he said that spontaneously. He banged on the car door, the officer opened the door, and Santos said this on his own. This is part of his defense. We were carjacked.
Ms. McKenna, can I just go back, because I want to make sure that I absolutely understand. Have you finished answering Justice
I have
Cowan?
to ask Judge Cowan that.
Thank you.
I'm looking at the motion judge's findings that that gun 3 was found in May 1998, right?
Right.
I think it's a page before the one I saw where you were quoting from. It's paragraph 4. I think you were quoting from paragraph 6. It's not relevant at the moment. In Mr. Harwood's brief, he says that, and I take it this is before trial, that, is it Caillot? Is that how you pronounce the defendant Caillot's motion stated, this is before trial, the police may have confiscated the guns in an unrelated incident. The person from whom the gun was confiscated may well be the murderer of Carlo Clermy, and that's, or could lead the police to the murderer. So here we have not just casual matchups. Don't we have a very specific request to say, look at that gun?
Which one, Your Honor? I mean, that's the problem. It's so vague. Which one? Which gun that's not that didn't focus on any specific gun, that motion.
It
That
focused
motion
on
just
the gun
said-
used in Mr. Clermy's murder.
But we didn't know what gun was used in Mr. Clermy's murder. And
Well,
in
then
the
what is this, the judge's findings in the paragraph that is talking about May 1998? The testing matched the 9mm casings found at the scene of the Clermy murder.
in a motion in limine before trial, Mr. Leonard had filed a motion, just a vague motion saying the gun might have been recovered. He didn't specify what gun, where, and guns are being recovered in Brockton. I don't want to say all the time, but guns are being recovered. He didn't specify any particular incident. In the
thought
2
he
years
did. I mean,
since
at
the
least
murder, it was
well.
sort of just a vague. A gun could have been recovered.
Well, I think what the Chief Justice is concerned about, and
Sure.
I have the same question, is that in paragraph number 4, which is on page 9 of the appendix, I gather, in the blue brief of Mr. Barter, it says, on October 02, the Commonwealth produced documents showing recovery of Glock 9 on or about May 11th, 98, and its delivery to State Police Firearms ID Unit for exam and testing on the same day. The testing matched the 9mm Glock to casings found at the scene of the Clermy murder. Now, was that testing done on May 11th, 1998?
No, and there's no time in
Yeah,
here.
that's the trouble. That sentence
Right,
doesn't
the
say.
sentence, it's just a bad sentence. And I think if you go on and read in context the rest of the, thank you for clarifying that. If you read in context the rest of what the judge says, I think that explains that. But it's just a bad sentence. There should be a date before that. The judge isn't making a finding that same day that happened.
So when
Your
are you
Honor.
saying that the match was made?
I'm saying that we don't know exactly when the match was made, but sometime after trial.
And what is there in the judge's findings that establishes that?
Where he says, first where he calls it newly discovered evidence, that alone, and then where he says that no one had any idea of the significance of the guns in paragraph 7, in paragraph 8, and in paragraph 6 on page 7 of his decision.
Thank you, Ms. McKenna.
Thank you very much. Thank you for your kind attention, and I would ask that you affirm the convictions.